Aviation joint stock at FW Aviation Holdings Limited.
Yes.
Rules, my lady, I appear on behalf of the appellant VietJet with Mr. Milner and Mr. McWilliams.
Yes.
My learned friend Mr. Lissack and Mr. Loff appear on behalf of FWA.
Yes.
My learned friend and I have discussed timing.
Good.
And we've agreed to split time. I'll finish by 12:30, and that's how we proceed. Your lordships should have, and my lady should have, a call bundle, supplemental bundle, and a joint authorities bundle.
We do.
And if I can just give a brief roadmap, I'm going to cover 4 topics. First of all, to give an overview, to say something very brief about the facts. Then I'll turn to the decision below, and then I will deal with the arguments. By way of overview, we say that this is an unusual case. It is about a court order. VietJet was subject to an injunction in relation to 4 aircraft. The injunction prohibited it from doing various things. For our purposes, what matters is that it prohibited VietJet from, and I'm quoting from the order, interfering with the claimant's right to possession, custody and control of the aircraft. As the court knows, in 2023, a series of letters were sent by VietJet or its lawyers to the Civil Aviation Authority of Vietnam and a number of Vietnamese government officials. No one alleges that VietJet breached the prohibitory injunction in sending these letters. No one alleges that any of the recipients of those letters interfered with the claimant's right to possession or control of the aircraft in response to the letters. In fact, no one alleges that those letters had any actual effect at all. Instead, what is alleged by FWA is that VietJet, in sending the letters, attempted to procure the recipients to interfere with the claimant's right to possession and control of the aircraft. That is, it is said, was a contempt of court. If I may, I'll start off with some basic principles about the contempt of court. When it comes to contempt of court, the law has long recognized a distinction between civil and criminal contempt. For an authoritative explanation of the distinction, one can do no better than the decision of the Supreme Court in Attorney General and Crossland.
Do you want us to turn to that?
Yes, please. It's in the authorities bundle, and it's page 84. And for present purposes, if we could look, please, at paragraph 23, and this is from the judgment of Lords Lloyd Jones, Hamlin and Stevens. And this is page 84, paragraph 23. In the words of Lord Toulson, and then there's a definition of criminal contempt, but then goes on to say, in the present case, is not a case involving a breach of an order by a party to litigation where the order has been made at the instance of an opposing party and its purpose is simply to protect the private rights of the other party. So that's a definition of civil contempt. And it's obviously concerned with a specific failure to comply with a court order by which the contemnor is bound. Now, just going above that passage, from the case of O'Brien, there's a definition of criminal contempt is conduct which goes beyond mere non-compliance with a court order or undertaking and involves a serious interference with the administration of justice. So just pausing there, goes beyond mere non-compliance. And I'll come back to that. But in the context of court orders with which we say we're concerned, criminal contempt liability on the part of the respondents ordinarily arises in the form of a civil contempt. And I stress ordinarily because there may be an exception which I'll come to. And the central question is always, has the respondent disobeyed the order? As the liability of the respondent is essentially strict, and because of the potential serious consequences of a finding of contempt, in other words, loss of liberty, the courts have stressed on a number of occasions the existence of a high standard of fairness. And by contrast, when we turn to third parties, in other words, those who are not bound by the injunction, their potential liability arises only under the criminal contempt jurisdiction. And a third party cannot breach an injunction to which it is not subject. Its liability arises only if A, it aids or abets the respondent's breach, I stress the respondent's breach, or it knowingly acts in a manner contrary to the terms of the injunction, thereby subverting the court's purpose and interfering with the administration of justice. In other words, this covers knowingly acting contrary to a court order. And so, although the two jurisdictions are distinct, civil and criminal, but this, in my respectful submission, is a short answer to this appeal, they have one feature in common. That is that they both depend on an act being done which is contrary to the terms of the injunction. That means either a breach of the injunction if the party doing the act is a respondent, or otherwise an act that would be a breach if it was done by the respondent. So that, my submission, is the central point and why this appeal, we submit, must fail. Now, turning to the facts, those principles, as I say, lead to the conclusion that there is no arguable basis for saying that my client VietJet is in contempt of court. And there's 2 points here. The first is that FWA does not allege a civil contempt. It does not contend that VietJet has committed a breach of the prohibitory injunction. And then secondly, FWA cannot rely on the third-party criminal contempt jurisdiction because VietJet is not a third party to the injunction. It is a respondent and a party to the very proceedings in which the injunction was made. That jurisdiction, therefore, has no application in either of its forms that I identified a moment ago, either aiding and abetting a breach by the respondent because there is no breach, or doing an act which would have been a breach if done by the respondent because VietJet is a respondent and again it committed no breach. So the question is, well, why are we here? And we say that to maintain its position, FWA must therefore invent a new and unprecedented form of criminal contempt, one that has never been previously recognized. It argued, and perhaps the best way to look at this is my learned friend's skeleton submission, which you will find in the core bundle at page 38, paragraph 2. So, see at the top there, so it argued that an injunction respondent, and this is the important passage, actively seeks the intervention of third parties with the intention that they take steps to undermine the state of affairs which the injunction seeks to maintain or create, is interfering with the administration of justice and is so liable in criminal contempt. So that is the way the case is put. And if we can break it down into 3 parts as to how the case is put. First, that the contempt may arise not from the respondent doing something contrary to the injunction itself, but from seeking the intervention of third parties. That is, of course, one conduct one step removed from the order's direct scope. Secondly, that what matters is the intention behind that conduct, an intention that those third parties act in a way said to undermine the state of affairs created or maintained by the injunction. That, of course, is the mens rea. Then the third element, that is the state of affairs, is to be determined not by construing the express language of the court's order, but by what a judge later concludes was its underlying purpose or spirit. And that last point is what makes the formulation we submit so radical. It shifts the actus reus of contempt from a clear breach of a defined prohibition to a much looser inquiry into the underlying motive behind the order and the judicial perception of it. We say that that is a radical and far-reaching extension of the law because it replaces the certainty of the court's order with a kind of judicial impressionism, contempt based on not on what the order says, but on what it is later thought to have been the underlying or ultimate purpose behind it. Now, the court is familiar with the principles relating to the law of contempt. It's there to uphold the authority of the court, not to punish conduct merely thought to be contrary to its mood or intention. Orders of the court must speak for themselves. Their scope and consequences must be clear. To extend contempt beyond breach of the court's order would, we submit, undermine that essential certainty, exposing parties to penal sanction on grounds of inference and impression rather than the law. So we say that FWA's case is wrong in law and that it advances a new and unfounded form of contempt liability which should be rejected. We also say that the position is straightforward. In other words, a respondent cannot be in contempt of an injunction without breaching it. And that was the very ground on which Lord Justice Phillips granted permission to appeal. And the reference there is called Bundle 77. So to show why that is so, and this is really coming to how we're going to put the case, we break the issue down into two parts, and they correspond to the two reasons why FWA has not been able to allege a breach of the injunction and a civil contempt. First, and the reference here is paragraphs 55 to 60 of our skeleton, can it ever be a criminal contempt for a respondent to an injunction to procure a third party to do an act said to, quote, undermine the state of affairs which the injunction seeks to maintain or create, if the respondent itself has not breached the injunction? And we say that the answer to that question is it cannot. The very proposition makes no sense, because the state of affairs which the injunction seeks to maintain is no more and no less than what the terms of the injunction stipulate. You therefore either act contrary to the injunction and thereby potentially interfere with the administration of justice, or you don't act contrary to the injunction, in which case you are not by definition interfering with the administration of justice. And if that submission is right, we submit the judge's order cannot stand and the appeal must be allowed. The second limb of this argument, which we set out in paragraph 65 of our skeleton, is that even if such a form of contempt existed, and we say it does not, could it be committed where the respondent merely attempts but ultimately fails to procure the third party to act? Put another way, is the actus reus of the contempt an actual interference with the administration of justice, or merely the creation of a risk of interference? And we say that if this species of contempt exists at all, which we deny, it would require proof of actual interference. On that basis, too, the judge's order cannot stand because it is accepted that no such interference occurred in this case. Now, if I can just make three brief observations before I move on to the facts. The first is the one I've just made, which is that this is a novel contempt application. There has never been a case where a respondent to an injunction has been found to have committed a contempt in relation to the injunction, either by actually procuring a third party to do an act that has the effect of circumventing the injunction, or by attempting to do so. Indeed, our researchers have not even been able to locate a case where this allegation has been made. Now, of course, what we do not say is that because there's no authority that that's an end of it, but we say that this is a novel submission and therefore needs to be looked at very carefully, particularly because if this type of contempt does exist, it's rather surprising that it hasn't been argued before, because if the liability exists, as FWA says, it would not only be a very viable option, but a very attractive option in the contempt context. The second point, in terms of overview, rather observation, is we acknowledge that the decision of the judge below was a decision on an application to amend. We therefore accept that we have to show that the allegations have no real prospects of success, but we do not shrink from submitting that that test is met, because the ultimate question, which is whether the facts alleged disclose the actual reus of criminal contempt, is one of law. And our argument is based on undisputed facts. And if we are right that it cannot be the actus reus of criminal contempt for a respondent to attempt to do something which is contrary to the animating purpose of the injunction, but is not a breach of the injunction, that will dispose of the allegations and no purpose will be served by a factual inquiry into whether anyone had the relevant mens rea. So the fact that if this allegation goes, the quicker the better. The third point I wanted to make is that the judge, while he granted permission for these contempt allegations to proceed to hearing, holding that the 3 allegations had sufficient merit, as we note in paragraph 4 of our skeleton, the issue with which this appeal is concerned is not addressed anywhere in the judgment. And of course, we take into account and accept that this was an extempore judgment. And this issue really only came to focus during the hearing, because until the hearing, it was unclear what kind of contempt was actually being alleged. Nevertheless, we did submit below, both in writing and orally, that if there was no breach of the injunction being alleged, then as a matter of law, the allegations simply do not disclose a viable case of contempt. But the judge did not engage in that argument. So although this appeal, therefore what this really means that this appeal therefore focuses on principle rather than looking at the judge's reasoning, because it's simply not there. But as I say, we don't shrink from the fact that this is a matter which we say the court should address and where the answer is clear. So that's all I wanted to say by overview. As to the facts, they're set out in our skeleton in paragraph 9 to 23, where we go through the dispute, the order, and the various contempts that are alleged. And unless the court wants me to do so, I was proposing just to skip the facts, because I'm sure the court's familiar with that background.
Yes, we think we are fully on top of the facts, or
Thank you very
on
much.
top of the facts to the extent that we need to be, Mr. Mann.
I think perhaps there's one addition to your 9 to 23, which is that the appeal you refer to has now been dismissed.
Yes. Yes, I should.
So you said judgment is awaited, but that has now
Exactly.
been dismissed.
I should have referred to that. And thank you for drawing. There is a pending application to the Supreme Court.
Inevitably.
Yes. Now, the third topic I wanted to cover was the judgment. The 2 new alleged contempts are referred to as the May letters.
So you want to take, do you want to take us to the judgment?
I'm just about to come to. I will do.
Okay.
Can I just say this?
Yeah.
At the outset, it appeared that FWA was alleging that those letters amounted to actual breaches of the injunction. And the supporting evidence, and I don't need to take you to it, but it's in Baker 3, paragraph 67, supplemental 252. It referred to a contemptuous breach of the injunction. And the learned judge below referred to the claimant's application as a violation of the prohibitory injunction, which is called Bundle 66, paragraph 7. But be as it may, at the hearing, FWA clarified that it was not alleging a breach of the injunction, and the judge thought and noted that he thought it was clear what was being made. And if we can look at the judgment now, and taking up my Lord's invitation, it's the passage I wanted to look at was in Core Bundle, paragraph 71. Sorry, paragraph 18 rather. And I wanted to look at paragraphs 18 and 19. And what?
Page 71.
Yeah, page 71. Thank you. And if we look at paragraph 18, what the judge says is this: I take the point that Mr. Milner makes, namely that on the least of the face of contempt 3 allegations, there is an allegation of violation, to use the word adopted, of the prohibitory injunction. Yet Mr. Lissack has explained already today that what he has alleged is not a breach of that injunction, and therefore not a civil contempt, but rather a criminal contempt of the sort to which our lich refers to. In reality, however, I regard the clarification as being no more than that. The thrust of the complaints made, it seems to me, is quite clear. It is very much shorthand that VietJet and the other 2 proposed defendants sought to undermine or interfere with the administration of justice including the existence of, including the essence of what was ordered through the prohibitory injunction, if not the literal substance of the order. So there's 2 points that I wish to make on that. First of all, the judge did not address the central question now before this court, a question, as I say, that was squarely raised below, namely whether it is even conceptually possible for a respondent to be in contempt in relation to an injunction without breaching it. Secondly, instead of grappling with that question, the judge simply recited the allegation that the defendant sought to undermine or interfere with the administration of justice, including, and you've seen the quote, the essence of what was ordered through the prohibitory injunction, if not the literal substance of that order. It may assist if I pause on that expression. What the judge appears to mean is that the contempt is alleged not because the defendant did something that the order actually prohibited, but because they are said to have acted in a way that frustrated the spirit or the underlying purpose of the injunction, what he calls its essence. In other words, liability is said to arise not from what the order says, but from what the court later infers it was really meant to achieve.
When he says if not in the last line, he means albeit not.
Yes, that's my submission.
You say he's not eliding essence into literal substance.
I mean, the irony is that when one comes to construe court orders in the context of contempt, the courts say a strict interpretation should be adopted. But what we submit is being said there is that there is a liability that is not based on the language and therefore the existence of a civil contempt and a breach of an order, and therefore a move away from the clear objective language of the order to what we submit as a subjective assessment of its supposed intent. That is precisely the difficulty. The law of contempt depends on certainty. It depends on fairness. A person must be able to read the order and know from its terms what conduct is prohibited. To speak of the essence of an order is to invite punishment for something never clearly stated, for conduct that only later is said to have caused an undefined line. We say that such an approach carries real danger to the rule of law, because it substitutes clarity with impressionism, punishing people not for what the order forbade, but for what the order court later thinks it must have been to forbid. And that, as I say, undermines both legal certainty and also fair notice, principles which we say are fundamental to contempt jurisdiction. Respondents must not be left to guess at the boundaries of lawful conduct. So if I now then turn to the fourth part of my roadmap, now turning to the arguments. With that, we can now turn to the two aspects of the issue arising on the appeal that I identified earlier. The first aspect is whether a respondent to an injunction who is prohibited from doing something can commit the actus reus of a criminal contempt by procuring a third party to do that act the respondent cannot do itself. We submit that the answer to that question is no. Either the respondent is in breach of the injunction and in contempt, subject of course to mens rea, or it is not in breach of the injunction and not in contempt. The species of criminal contempt which can arise in relation to injunctions is confined to third parties. Third parties necessarily cannot be in breach of the injunction because they are not parties to it, but they can nevertheless commit a criminal contempt if they assist in the breach of it or intentionally frustrate its purpose. That species of contempt has no application to the respondent itself, not just as a matter of convention, but because it is conceptually impossible to apply it to the defendant.
Sorry, can I make sure I understood that? Because I think you've made a submission you didn't quite make in those terms before. You say it can't be contempt for a respondent to procure a third party to do something that would be a breach of the injunction.
Yes.
What happens if I'm a respondent to a freezing injunction and I instruct my bank to transfer some money?
The bank will be liable
Am I not liable?
Yeah, that on the terms there is a breach.
You're liable, the lady will be liable for the breach of the order.
Yes. And the third party would be liable. I mean, this is the
Well,
Zen
maybe
Limited.
it's the way you phrase it.
Perhaps I've been unclear. I'll come back to this point if I may in
Yeah.
a moment. But it's one that comes out in the authorities, which I'm
But
about
you
to
were
say to.
you were giving me the impression that it can't be a contempt if you successfully use the means of a third party to.
That would be a civil contempt. The third party liability is criminal contempt.
Yeah.
And that's the distinction that we're seeking to make.
Would you like to rephrase your submission, or just reflect on your last submission and repeat it in words you're comfortable with?
Yeah, let me just double check that I've got that right. But if I may, I'll come back to that.
What's the position, perhaps you could come to this in due course, what's the position if, in the freezing order example, the bank doesn't act on the customer's instructions? Perhaps because it knows of the freezing order, it's had notice, or perhaps just because it's inefficient. But the respondent to the freezing order has done everything it can by giving the instruction to remove the funds out of the jurisdiction or whatever, which the freezing order tells it mustn't do. Is the respondent then in contempt, in civil contempt?
No, because the money hasn't gone. There's no actus reus. There's no breach of the order.
So there's no principle of attempting or...
No, we'll come back to that.
in-
We'll come back to
in,
that point,
in
yes.
Civil contempt, is that?
That's my submission, yes.
I see.
Yeah, it all depends on the construction of the order. And the order may on its face cover the particular matter, but it's a matter of construing the order and determining whether or not there's a breach.
I can see the difference between an order which says must not remove and which says must not take steps to remove.
Yes.
For example.
Yes,
So
and that
there will be that question of
Yes,
interpretation.
yes.
But I was assuming it was the standard form which simply says must not remove.
I mean, we'll come to this point very shortly, but there is a distinction between the liability of the respondent who breaches an injunction and thereby is in civil contempt, and the liability of a third party for criminal contempt, and that we submit as a distinction which is fundamental and is reflected in the legal authorities. If we could turn to the Spycatcher case, which is in the authorities bundle at tab 8 at page 269. In that case, the Attorney General has obtained interim injunctions to prevent the Observer and the Guardian from publishing material from the memoirs of the retired officer of MI5. And pending the trial of the proceedings, extensive extracts and summaries of the memoirs appeared in the Independent and 2 other English newspapers, none of which were themselves respondent to the injunction. And the Attorney General sought committal proceedings. And the issue in that case turned on whether the newspaper's conduct could amount to a criminal contempt of court in circumstances where they were not parties to the action or respondents to the injunctions. The speech of Lord Oliver sets out the principles very clearly, and they can be found in the authorities bundle numbering at page 295. If we can turn to E, where it starts, the appellant's primary submission is that it not only was not, but was not capable of being a contempt of court, because although they were fully aware of the orders which had been made against the Guardian and the Observer, they were not themselves bound by those orders, nor were they assisting in or procuring or inciting a breach of those orders by the 2 newspapers which were bound. The submission involves some analysis of the particular type of contempt with which the appeal is concerned. But the distinction, which has been variously described as unhelpful or largely meaningless, is sometimes drawn between what is described as civil contempt, that is to say, contempt by a party to proceedings in a matter of procedure, and criminal contempt. One particular form of contempt by a party to proceedings is that constituted by an intentional act which is in breach of the order of a competent court. Where this occurs as a result of the act of a party who is bound by the order, or of others acting at his direction or on his instigation, it constitutes a civil contempt by him, which is punishable by the court, at the instance of the party for whose benefit the order was made, and which can be waived by him. The intention with which the act was done will, of course, be of highest relevance to the determination of the penalty, if any, to be imposed by the court. But the liability here is a strict one, in the sense that all that requires to be proved is service of the order and the subsequent doing of by the party bound of that which is prohibited. When, however, the prohibited act, underline the words prohibited act, is done not by the party bound himself or by a third party, a stranger to the litigation, that person may also be liable for contempt. There is, however, this essential distinction that his liability is for criminal contempt and arises not because the contemptor is himself affected by the prohibition contained in the order, but because his act constitutes a willful interference with the administration of justice by the court and the proceedings in which the order was made. Here, the liability is not strict in the sense referred to, for there has to be shown not only knowledge of the order, but an intention to interfere with or impede the administration of justice, an intention which can, of course, be inferred from the circumstances. Now, pausing there, then there's a discussion of the point that my lady Justice Falk mentioned about liabilities, in fact, about third parties. But just pausing there, in terms of, before we look at anything else there's a number of points that arise. First of all, there's this distinction between civil and criminal contempt. Civil contempt is about an act by a party to proceedings. Lord Oliver talked about contempt by a party to proceedings in a matter of procedure, and criminal contempt is in the context of injunctions, is about acts by a third party. Secondly, civil contempt arises from disobedience to a court order. It makes it clear that the order is for the benefit of the party seeking it and in fact can be waived, as we've just seen. The third point that comes out here is that while there are differences between civil and criminal contempt, what they have in common is that both of them require the doing of an act which is contrary to the terms of the injunction. And I invited the court to highlight the passage from Lord Oliver, where he talks about the situation where the prohibited act is done by a third party. There's no suggestion that there can be a contempt if no prohibited act is committed by anyone. And that point comes out in another decision, of this time of the Supreme Court, in the case of Wolverhampton, and it's in the authorities bundle at page 1008. And that's at tab 35 of the bundle. And just in terms of putting it into context, it was a judgment given by Lord Reed, Lord Briggs and Lord Kitchen, and the issue in that case was whether the court could grant an injunction against persons unknown to prevent trespasses on public land by gypsies and travellers. There is a section which discusses the effect of orders on third parties, and it's at paragraph 37 under the heading at page 1033. And what the court says in this part of the judgment: if non-parties are not enjoined by the order, it follows that they are not bound to obey it. they can nevertheless be held in contempt of court if they knowingly act in the manner prohibited by the injunction, even if they have not aided or abetted any breach by the defendant. As it was put by Lord Oliver, there is a contempt where a non-party frustrates, thwarts, or subverts the purpose of the court's order and thereby interferes with the due administration of justice in the particular action. And if we can move on to paragraph 41, what the judgment says, there is accordingly a distinction in legal principle between being bound by an injunction as a party to the action and therefore being in contempt of court for disobeying it, and being in contempt of court as a non-party who, by knowingly acting contrary to the order, subverts the court's purpose and thereby interferes with the administration of justice. So just pausing there, note the language, manner prohibited by the injunction. We say that that is crucial because it defines a scope of conduct that can lead to contempt by a non-party. It ensures that liability is not limitless. A non-party is only at risk if they knowingly engage in acts that the injunction itself expressly or implicitly forbids. In other words, the injunction must clearly identify what conduct is prohibited. A non-party cannot be held in contempt for merely acting inconsistently with the spirit of the order unless that act directly frustrates the court's specific prohibitions. And we say that that is a requirement reflecting the importance of legal certainty and fairness. In other words, a person should not face contempt sanctions unless the prohibited conduct is clearly within the terms or necessary effect of the injunction and they knew of it. So that phrase, so the phrase ensures a balance. It upholds the authority of the court while preventing overreach against those who are not party to the proceedings. And of course, although we're talking in terms of third parties, the same reasoning must apply to a respondent, which means that a respondent does not, if a respondent does not breach the injunction, it cannot be in contempt. Now, before we look at the question as to the principles that are reflected in that position, it might be helpful just to have a look at Arledge on the law of contempt in a textbook, and that's in the authorities bundle. And could I invite the court, please, to go to page 1128. And there's a discussion here, paragraph 3, 130, where the author says there is a clear authority that persons aiding or abetting or inciting disobedience to an order of the court are guilty of criminal contempt, even though disobedience by the principal contender would amount only to civil liability. This reflects the fact that civil contempt has always been treated as a contempt and procedure, which can generally only be committed by someone who is a party to civil litigation. And then at paragraph 132, there's a discussion of the inconsistency of this classification. And then there's a reference to the judgment of Lord Justice Lloyd, as he then was in Attorney General of the newspaper, where the distinction is referred to. And then at paragraph 3134, there's an explanation that the distinction is not as absurd as might first appear. In other words, there is a distinction between criminal and civil contempt because of the mental element. And then at 135, there's a discussion where I said there may be a qualification, and it's this, that where perhaps the position appears to be less satisfactory is in those cases where there is a deliberate or public flouting of a court order or undertaking by a person who is a party to the proceedings. Whereas in some jurisdictions, the damage to the administration of justice caused by such conduct may be regarded as criminal, in England it is still labelled civil contempt. The rationale of the distinction drawn in England between civil and criminal contempt does not appear to be based upon an assessment or comparison of the moral blameworthiness involved on the part of the relevant contemnors, but rather upon the procedural consequences of their conduct. However, if in any given case the court truly regards the civil contempt or principle, to use Lord Atkinson's phrase, as being more blameworthy than a third party associated with his contempt, then there is no reason why he should not attract a more severe penalty. And this is the key passage. Moreover, in appropriate circumstances, a party to civil litigation who manifests an intention to subvert the purposes of the court over and above the mere fact of non-compliance with an order could also be held, at least in theory, to be in criminal contempt.
Underlying a lot of your points is the proposition that the distinction between the language of civil, the labelling of civil and criminal contempt is, to use Lord Oliver's phrase, unhelpful, if not more, arguably confusing.
I mean, the point is that it's there. It's referred to on many occasions, and in the Supreme Court, and over and over. There's a number of cases, but it's there, and it's right to say that a number of criticisms have been made about the distinction. I think it was Lord Donaldson in one of the cases who suggested that the distinction should be changed by a distinction between breaches of court orders and other conduct, and have that categorization. And there's also at the back of the papers the recommendation.
The Law Commission.
The Law Commission.
Yes.
Who are changing it.
Yeah.
But I do submit that the principle is helpful to understand in the context of the present case, where one is talking about breaches of court order. It's much easier to regard those as a civil contempt because the principles are clear. It's certain, it's fair. There's a body of jurisprudence that deals with that position. The position of criminal contempt, of course, but it is different, and it's dealing with different types of conduct. I mean, the one example where it might be moved from civil into criminal is where there is a deliberate flouting of a court order. And that's the point that's really picked up at the end there in Arledge, that they're contemplating that there could be a criminal contempt. But the key point, and this is the essence to my submission, is that what it's talking about, and you can see there, is conduct that goes above the mere fact of non-compliance of the court order. So even there it's being assumed that there's a breach of a court order. And in the feature that makes this case, in my submission, the reason why the reasoning cannot be maintained is that it's common ground that there's no breach of a court order. And that's why my friend did not argue for a civil contempt. So once it's accepted that there is no breach of a court order, on what basis can there be a criminal liability which regards going conduct beyond a breach of a court order, which is not in the present case?
Well, what are the practical consequences for somebody, depending on whether they are held in civil or criminal
there are
contempt? I mean,
well, there's differences in terms of the mens rea, as for example, one.
No, but I mean, is the maximum penalty the same? The rights of appeal are the same these days, are they?
Yeah, there's a helpful list at 1173.
Oh, is there? Thank you.
That's in the Butterworth extract.
Yes.
Oh.
That didn't seem to include length of sentence.
I think they're all 2 years, aren't they? I'm told they're all 2 years.
I mean,
Yeah. I mean,
casting an eye down this list, they're quite arcane, some of these distinctions.
I mean, we agree
Breaking open
that
an outer door, even on a Sunday.
but I mean, whatever one wants to say about the distinction between civil and criminal contempts, I come back to the point that we've already made. But as I said, they're both concerned with acts prohibited acts, in other words, breaches. There's no basis in our submission for finding civil contempt, and that's common ground. It's not alleged. And in our submission, there can't be a criminal contempt because we go beyond using the phraseology of Arledge, which talks about going beyond mere disobedience, and that's of a court order. And so that is the points that really come out of the passage of Arledge, is that although they say it is theoretically possible for a respondent to an injunction to be in criminal contempt, that is contemplating a situation where there is in fact a breach of the order, but the breach is especially serious or contumacious, as one might put it.
I mean, that's clearly not complete, is it? Because a respondent to an injunction could, disrupt court proceedings or something like that. So
accuse the judge of bribery.
You must confine it to the context being a court order.
Yeah, it's got it. It could be something totally independent of the injunction. It could have been a conduct in court. It could be intimidating a witness. It could be untrue statements. It could be a whole variety of conduct. But when one's talking about in the context of court orders, as we are in this case, what we say is that what's common to both civil and criminal contempt is that there's got to be a prohibited act, using the language of Lord Oliver, and as reflected in his speech and also in the Wolverhampton case.
Is it too reductive to say the crucial distinction is this between acts breaches by the party to the injunction, where strict liability applies, and other breaches for which intention must be established? And where intention is established in the case of a respondent, a party to the injunction, that's an aggravating feature.
Correct.
Well, that's why all this labelling of criminal and civil might arguably be, as Lord Oliver said all those years ago, unhelpful.
Yes.
If not more.
But I mean, just coming back to this passage where one might. The simple way of looking at this would be to say that where one is dealing with breaches of court orders, it should be civil contempt or nothing else. But that obviously is not the law, as reflected in this passage, which seems to contemplate that there may be circumstances where the conduct is so bad that it might be said that the criminal liability is said to exist. But the point is that it's common to both that there is a prohibited act, and it's common ground in this case that there is no prohibited act. And that's why we say that the judgment below is flawed. But I mean, what comes out of this is that the passage that we just looked at is not contemplating and provides no support for the proposition that the respondent can commit a criminal contempt in relation to an injunction without breaching it at all. That has never been suggested to be the position, even in a theoretical scenario, let alone an actual case. And my learned friends refer to a case called Malhotra, Supermax, but we don't see that authority provides any assistance at all, and I'm not proposing to deal with this at this stage, and I'll come back in my reply if necessary. But that case certainly doesn't provide any support for the notion that there can be a criminal contempt by attempting to circumvent an injunction where the conduct is not contrary to the injunction and not otherwise wrongful. Now, I wanted to just look at this as a matter of principle. So the submission is that there is no authority that there is a contempt in this case unless there is a breach. And we say that reflects an important reality, that there cannot be a contempt in this type of case where there's no breach. And the reason for that is that all the protections that are inbuilt into the law of contempt are there for the protection of the respondent, and all those protections would be lost if the FWA is right in their submissions. So, just to give examples, for example, the principle that the injunction must be clear and unambiguous. so that the respondent is left in no doubt as to what acts are and are not prohibited. And if we could just briefly turn, please, to a judgment of Lord Justice Popplewell, and you'll find that in the authorities bundle at tab 1, page 2026.
What's the case called?
ADM.
ODM. Just
And the passage I was going to look at is at paragraph, page 26.
the quote from Punch.
Yes, and exactly. In terms of the principle, and there's one other passage in the judgment that I'm, in terms of the principles in play. I mean, they're largely consistent, the same as what I've said before. But if one turns back to paragraph 51, you see this distinction where one is dealing with a person to whom a court order is addressed as guilty of a contempt if they breach it. Deals then with the position of third parties, makes this distinction between civil and criminal contempt, although the labels are controversial and in some circumstances misleading. It is convenient to adopt them for the purposes of issues which arise in this case. And so that's the first case I wanted to refer to. The second principle in terms of the protections is the principle that the court construes orders restrictively, that the order must be clear and unequivocal and strictly constructed before a respondent is found in contempt. And reference to support that proposition is in Pan Petroleum and Yinka, which is at Authorities Bundle tab 22.
Well, isn't that covered by the Punch quotation that Lord Justice?
Well, I'm not sure. Let me just check that.
Sorry, I come across.
I think it does add it does.
Okay.
It's at page 740. My lord, I think it is worth just looking at it because it deals with the question of restrictive construction. Such are the penal consequences that the order must be clear and unequivocal and strictly construed before a party will be found to have broken the terms of the order and thus in contempt. The third point is that another principle which I think I can leave that one out. So what these protections all recognise is, as a matter of fairness, that a respondent to an injunction must know exactly what he is to do, what he cannot do, and by necessary implication, what it can do. And if it is intended to make a given action or inaction a contempt, this must be by clear and express language and not some flexible or purposive interpretation outside the literal words of the order. And we submit that to accept that a respondent could be in contempt for committing a deliberate act which the injunction does not prohibit, would, we submit, render these protections nugatory. A respondent would have no certainty as to what was the injunction designed to achieve. The extent of rights and obligations would not be contained within the four corners of the order, and rather it would be necessary to embark on what might be a complicated exercise to work out what acts, although not prohibited by the injunction, could nonetheless be held to amount to a circumvention or attempted circumvention of the injunction and thus a criminal contempt. And we say that that would be intolerable. And we submit also that the facts of this case are a good example of how difficult that judgment call could be and the latitude it would afford aggressive claimants to apply pressure on their opponents. FAW has chosen to characterise the mere sending of the letters by VietJet to its regulator, asking for guidance, which it accepts involved no breach of anything, as conduct intended to circumvent the order and thus a contempt. And we say that it's no answer to say, as my learned friends say in their skeleton at paragraph 36, that a third party can work out from the injunction that which it seeks to prevent, that third parties have to undertake a similar interpretive exercise. It's not an answer because it's wrong. Third parties don't have to undertake the exercise. They know that to the extent that the injunction affects them at all, it only prohibits them from doing the same acts that the respondent is prohibited from doing, nothing more. And that's why the respondent's argument cannot be right as a matter of logic. For the actors of a criminal contempt to be committed in relation to an injunction, there has to be an act prohibited by the injunction, just as there does in civil contempt. And there are a number of if I could refer to the Punch case, where there are clear statements to that effect, and that authority is in the authorities bundle at page 187, the relevant passage. And this was the one involving, I think, Shayla. And the terms of the injunction were set out in paragraph 8 at 187 at letter B. So that's Mr. Shayla was restrained from, and then it sets out the terms of the injunction. And the question that arose in that case was whether the defendant had acted contrary to the purpose of that injunction, which required a determination of what that purpose was. And what was decided by the House of Lords, that the purpose would be frustrated by the publication of anything within the terms of the order, and that it was wrong in principle to inquire into whether the order had some narrower ultimate purpose. And so that's the point that comes out of that, which is that purpose is essentially the same as the terms of the order. So if there's no breach of the order, there's nothing to be said to justify going outside the terms of the order in order to find a purpose and a contempt. And that's clear from the speech of Lord Nichols at paragraph 40 at page 192. And what he says is this: the second point is that the purpose of the court in making an interlocutory injunction means no more than the effect its terms show it was intended to have between the parties to the action in which it was made. Normally there will be no difficulty in gleaning this purpose from a reading of the order. The purpose of the order and its terms are co-extensive. It is right that this should be so. If third parties are bound to respect the purpose of an order made in an action between other parties, it is essential that they should be able to perceive this purpose readily from the reading of the order. And then paragraph 45 over the page, where it said that difficulties from this straightforward approach runs into serious practical difficulties. If in this context the purpose of the order in granting an interlocutory injunction means something other than the effect its terms show it was intended to have between the parties, how is a third party to know what to do? How is a third party to know what is the purpose which it must respect if it is something other than the purpose evident on the face of the order? Uncertainty is bound to follow, with consequential difficulties in proving that a third party knowingly impeded or prejudiced the purpose the court sought to achieve when granting the injunction. I see no justification or need to go down this route, which is not supported by authority. And then in the speech of Lord Hoffman, at paragraph 76, at page 199 of the JAB, he says the purpose of the order was therefore, in my opinion, simply to prevent from happening whatever the order said should not happen. And so what this means is that a third party simply has to read the injunction and see what it is that the respondent is prohibited from doing. And if the injunction has any effect on the third party at all, then the third party is likewise prevented from doing those things. But a third party is not prohibited from doing something that the injunction doesn't prohibit. And that is an answer to the point made by my learned friends in paragraph 35 to 36 of their skeleton, which is in the core bundle at page 67.
Punch was the converse of our case, wasn't it? Where the argument was that the purpose of the order was narrower than its terms.
Correct.
Whereas in our case, the argument is that the purpose of the order is wider than its terms.
Exactly. Now, so if we can just look at 35 to 36, my learned friend's skeleton. But it's not just the answer to that point, it also shows that the approach, page 47 of the core bundle. And the point here is, and why we say it's misconceived, is that because it follows from the fact that the purpose of the injunction is synonymous with its terms, that the respondent to the injunction cannot be in contempt by frustrating the purpose of the injunction absent any breach. In other words, the only way that the respondent could do something contrary to the purpose of the injunction is necessarily to breach it. If there is no breach, there is by definition no frustration of purpose, and thus no criminal contempt. And my learned friends say, well, if our approach is right, there's a lacuna, and that's dealt with in their submissions at paragraph 32 of the skeleton, that an inability to find a respondent to an injunction in criminal contempt in such circumstances would leave a lacuna in the law and afford considerable scope for impunity. And the example they give of the problems that might arise is what they describe as the spy catcher scenario, where a newspaper subject to an injunction against publication passes the relevant material to a third-party newspaper, intending that that newspaper should publish it. They assert that if VietJet is right, the second newspaper commits a contempt, but the first newspaper doesn't, and they say that that would be wrong. But my lady, the answer to that question is to be found in the Skycatcher case itself, because the injunction that the Attorney General obtained is set out in the judgment below of the Vice Chancellor, Sir Nicholas Brown Wilkinson, as he then was, which you will find in the Joint Authorities Bundle, tab 5, at page 128, at letter G, where the terms are set out in very broad terms, where the defendants and each of them be restrained until trial or further order from doing, whether by himself or itself, or by his or its servants, or agents, or any of them, or otherwise however. And the target's newspapers were thus prevented in terms of the injunction from passing the material to third-party newspapers. And that's the answer to the point. The scenario that FWA posits can readily be avoided by the applicant taking proper care in drafting the injunction. Any applicant for an injunction seeking to prevent the publication of confidential information will, if competently advised, ensure that the injunction prevents the respondent both from publishing the material and from passing the material to others. That then is our case as to why it can never be a criminal contempt for a defendant who is prohibited from doing something directly to circumvent the injunction by procuring a third party to take that step instead. If the court accepts that submission, FWA's case must fail and the appeal must be allowed. But there's another point to make in relation to the conduct which is the issue of whether it can be a contempt to procure such third-party conduct. And that's where we need to talk about the purpose of an injunction, and that there are, in fact, two aspects about a purpose of the injunction. One aspect of the purpose is what the injunction prohibits, and I've addressed the court already and shown that it is synonymous with the terms of the injunction. But the other aspect is whose conduct is intended to be restrained. And that is a separate question, and the answer to which may not be apparent from the terms of the injunction itself. So, for example, in the spycatcher case, what was prohibited was the publishing or causing or permitting publication of confidential information. The purpose of the injunction was the general purpose of ensuring that information subject to the injunction was kept confidential pending the trial. That purpose could be frustrated by any publication of the information. So any newspaper which knew the injunction would commit a criminal contempt. By publishing the information, the newspaper would be interfering with the administration of justice. But in other cases, the identity of the person doing the prohibited acts will be an essential aspect of the injunction. So that if an injunction prohibits A from doing something in relation to B, it will not be a contempt for C to do the same thing in relation to B, even if C knows all about the injunction. Now that distinction was discussed in the spycatcher case in the speech of Lord Brandon, which you can find at 283 of the authorities bundle. And it's letter G, 283 letter G. If you can just sort of read that to yourself, please.
The paragraph beginning, it seems to me.
It's a passage that starts, faced with these authorities, Mr. Lester argued. This is page 283.
Sorry, thank you.
Thank you. And at the bottom there, at 284 of the numbering, letter H at 206 of the judgment, it remains to consider in what circumstances conduct by C in knowingly doing acts which would, if done by B, be a breach of an injunction against him is such as to impede or interfere with the administration of justice by the court in the action between A and B. Now, just pausing there, it's worth noting that Lord Brandon frames the question specifically in terms of whether the conduct that would be a breach of the injunction, if done by the respondent, can amount to criminal contempt, which is entirely consistent with the passages from Lord Oliver and from the Wolverhampton case. And clearly there's no suggestion that conduct that would not be a breach by the respondent could be a contempt. And then what he goes on to say at the top of page 207, using the numbering of the authority, 285 of the joint authorities bundle, I do not think it would be wise, even if it's possible, to try to give an exhaustive answer to the question. A principal example, however, of circumstances that will have that effect is where the subject matter of the action is such that if it's destroyed in whole or in part before the trial of the action, the purpose of the trial will be wholly or partly nullified. This would be the situation in the case which I postulated earlier of an action in which B claims but A disputes that B is entitled to demolish A's house, but A obtains an interlocutory injunction against B restraining B from demolishing A's house pending the trial of the action. If in such a case C, acting of its own volition, and not by way of aiding or abetting, knowingly demolishes A's house before the trial of the action, the purpose of such trial would be wholly nullified. C will therefore be committed a contempt of court.
Does your submission on this aspect come to something like this, that a third party doing an act prohibited by an injunction may in some circumstances not be a contempt, e.g. the trespasser example, but conduct which is not prohibited by an injunction can never be a contempt?
Correct.
Okay, that's...
And this distinction between cases where the injunction extends to third party actions and those where it doesn't have been described aptly as the purpose of identifying the purpose of the order. And that's the language of Mr Justice Adam Johnson in Ocado, McNeve, which is in the authorities bundle at 694, paragraph 151. So it's a distinction about identifying the purpose of the order. And in this case, if there was to be any interference with the export, it would have been done by the Vietnamese authorities. It is quite obvious and not in dispute that it was no part of the purpose of the injunction to constrain lawful actions of the Vietnamese authorities in relation to aircraft. These authorities were free to exercise their statutory powers under Vietnamese law as they saw fit. They were not bound to have regard to the injunction at all. So the oddity that FWA points out, that they even go to call it perverse, whereby the third party could be in contempt and the respondent would not be, can't arise on these facts. Here, if there was no breach by the respondent VietJet, there could be no contempt either by the respondent or by the third parties that it sought to influence, the Vietnamese authorities. And I've already made the point that even where that distinction could in theory arise, it can and should be straightforwardly prevented by sensible drafting. So there is no lacuna, there's no perversity in my submission, and particularly in a case like this where the injunction is not intended to affect third parties. And
of course, in this area, these cases from the House of Lords some years ago, there's often a plethora of judgments from judges saying hopefully the same, but usually slightly different things. Do you want to take us to what Lord Oliver said on this point, which I noticed Mr Justice Adam Johnson went on to consider, and I was just having a look at page 223 of Spycatcher. That, after all, was what was quoted by Lord Hoffman in the passage you took to us earlier. And if you're not going to, you're going to do that. Then.
No, I wasn't, but perhaps I should. Let me just want to make sure that covered the point.
I think it's the passage at page 223 of his. Unless you feel it's already covered in what you've taken us to.
Well, I think so, but I just want to double check.
But there's I noticed that Mr Justice Adam Johnson referred to it.
Yeah, well, let me just get his.
And it is sidelined in our hard copy. 223, top of the page. 223 of the report, so 301 of the bundle.
Yes.
302. That passage at the top of 301 sideline is, I think, quoted by Lord Hoffman and by Mr Justice Adam Johnson. If nothing turns.
No, I don't think anything. I mean, it's obviously the speech of Lord Oliver is important. I've already referred to it. I think it comes down to the point that the purpose of the order is to be determined by the terms of the order, and therefore a theory of liability that accepts that there is no breach of the order, but by some purposive interpretation there is a contempt, we say is inconsistent to basic principles concerning the law of contempt, which are all about certainty, fairness, following the terms of the order, strict construction, and as we've seen from the passage of Mr Justice Picken, where he went wrong was to move into aspects of essence in an investigation which has no part of this area of the law. And that was we submit the mistake, the error, which leads to the conclusion that there is no contempt in the present case. The actus reus, the prohibited act, is the breach of the order. And whether one wants to look at that as a matter of civil contempt or criminal contempt, you've still got to get that actus reus, and it's common ground that it doesn't exist in the present case. And that's why the matter fails. I mean, the second argument I can deal with, which is the second aspect of the appeal, is whether it can be a criminal contempt using the quote circumvent an injunction by persuading a third party to do something. The respondent can commit the actus reus of a contempt merely by attempting to do that, or is actual circumvention what must be made out? And just in terms of your note, we raise this point in paragraph 65 of our appeal skeleton, called bundle page 34, when from their notice of objection, we could see for the first time clarity on the basis of what FWA was alleging, that contempt of liability could arise, as to how it could arise. But it's a point on which FWA has little to say in its latest skeleton. They touch upon it, but only briefly, in paragraphs 47 and 48 of their skeleton. Cross-reference there is called bundle 50, and only there do they assert that success is not the prerequisite in criminal contempt. Now we say, for reasons of principle, the distinction between an attempt and success is important in this context, and that a respondent cannot commit the actus reus of criminal contempt by a mere attempt to circumvent an injunction, or for that matter, an attempt to breach an injunction, which of course is not alleged in this case. It's not alleged that we've attempted to breach an injunction and therefore there's a civil liability. It's all about an attempt to circumvent the injunction. If I can go then to, again, there's a complete dearth of a precedent to support FWA's case. If we could turn to one Supreme Court decision, which you've already seen reference to, O'Brien, and that's in the authorities bundle at 459. And that was just in terms of background, that was an extradition case where the question was whether a civil contempt was capable of being an extradition offence. And the Supreme Court held that it wasn't, distinguishing a civil contempt from a criminal contempt for those purposes. And if we turn, please, to paragraph 38 at page 470 of the bundle. You see a reference to the distinction between paragraph 37, between civil and criminal contempt, and then paragraph 38, it's stated, breach of an order made or undertaking obtained in the course of legal proceedings may result in punishment of the person against whom the order was made or from whom the undertaking was obtained as a form of contempt. As Lord Oliver observed in Attorney General Times, although the intention with which the person acted will be relevant to the question of penalty, the liability is strict in the sense that all that is required to be proved is the service of the order and the subsequent doing by the party bound of that which is prohibited, or failure to do that which is ordered. However, a contempt of that kind does not constitute a criminal offence. Although the penalty contains a punitive element, its primary purpose is to make the order of the court effective. A person who commits this type of contempt does not acquire a criminal record. A criminal contempt is conduct which goes beyond such non-compliance with a court order or undertaking and involves a serious interference with the administration of justice. Examples include physically interfering with the course of a trial, threatening witnesses or publishing material likely to prejudice a fair trial. The distinction is not unique to English law. A similar distinction is recognised in the USA. In Turner and Rogers, the US Supreme Court had to decide whether the due process clause of the US Constitution granted an injured defendant a right to state-appointed counsel in civil contempt proceedings, which might lead to an his imprisonment. Justice Breyer said that civil contempt differs from criminal contempt, is that it seeks only to coerce the defendant to do what the court has ordered him previously to do. So just pausing there, again, another statement, which is that criminal contempt is conduct which goes beyond mere non-compliance with a court order. And that ties in with the passage that we looked at, the theoretical passage discussion in Ardledge, where it said that a breach of an injunction might possibly be a criminal contempt in theory, but only if it went above and beyond the fact of breach so that it was even more blameworthy. Self-evidently, we submit that a failed attempt to breach an injunction cannot possibly be said to go beyond non-compliance with the injunction. To the contrary, it is by definition something less than non-compliance, not something more than mere non-compliance. And if that is right, it makes no sense to say that an attempt to circumvent an injunction, that is, an attempt to do something that is not a breach of the injunction, goes beyond mere non-compliance. Plainly, it does not. It is inherently less blameworthy than non-compliance. Indeed, if a respondent does something that is not contrary to the terms of the injunction and is not otherwise unlawful, then it is difficult to see how it can be said to be blameworthy at all. It is possibly absurd to say that that is somehow worse than a breach of an injunction. Ultimately, FWA's argument, in paragraph 48 of its skeleton, cross-reference there is page 50 of the bundle, that an attempt is good enough for criminal contempt is based on a misconception about the actus reus of criminal contempt in relation to injunctions. Now, in their skeleton, they cite two cases in a footnote, which it says shows that there is no difference between an attempt to interfere with the administration of justice is successful. We don't see anything in those authorities that support that proposition. They're cases of witness intimidation, where the actus reus of the offence is creating a real risk of interference with the course of justice. But that does not mean that any act that creates a risk of interference or an attempt to interfere can be a contempt. And there is a body of authority which I can briefly take you through, which makes it quite clear that in every formulation, it is all about interference with the administration of justice, and there is no formulation which speaks in terms of attempts at circumvention or attempts of breach. And if I can just briefly take
just a moment. Do you want just to give us the list of authorities?
Yes.
And then, if we think we need to dive into any of them, we'll let you know.
Yes.
At this stage.
I mean, the first is AG Newspaper Publishing, which is Authorities Bundle 124, page 164, Sir John Donaldson. The next one is Lord Justice Balcom in the same case, 286G, where he talks about the two elements being conduct which interferes with the administration of justice as the actus reus. Then there's Ocado and McKeith, at page 157, which is authorities bundle at 695, referring to the judgment of Lord Bingham as Chief Justice at that case in AG newspapers, where he talks about the need to show some significant and adverse effect on the administration of justice. And that's quoted in Ocado and McKeith, authorities bundle 695, paragraph 157. There's AG and Punch, which is paragraph 48 of the speech of Lord Nichols, authorities bundle at 194, where he talks about thwarting the purpose of the injunction. Ocado at 690, paragraph 131, which talks about the actus reus involving the claimant, showing that the defendant's acts have in fact interfered with the due administration of justice. And those are the authorities. And what they show is they consistently phrase the actus reus in injunction terms, in terms of an act which actually interferes with the administration of justice or actually thwarts the purpose of the injunction. A mere risk of interference or an attempt to interfere which doesn't achieve its purpose has never been held to be sufficient and is not sufficient. And the fact that no actual interference is alleged in this case is therefore a second independent reason why FWA's allegations do not on their face disclose a sustainable case of criminal contempt. Although there was one authority I haven't referred to, which is the BHP case. We don't think on analysis, we contend it's not relevant on analysis, but I reserve my right to come back and reply if it's necessary. Can I just check if I've covered everything? I appreciate I haven't come back and done a reformulation, if I may think about that one. With my
I
colleagues.
think you've more or less picked it up.
I hope so. Anyway, that's all I wanted to say.
Thank you very much.
Thank
you very much. Yes, Mr. Wilson.
May I please do my lords, my lady? May I just check, do you wish to have a break for the shorthand writers or to continue?
Would the shorthand writers like a short break? 5 minutes?
5 minutes would be much appreciated.
As we managed to do here, Mr. Malik, in 75% of the time that he suggests was good going, we'll have 5 minutes. Thank you very much.
Court rise and able.
ahead of my time.
Well, that's uncommonly generous.
Uncharacteristically generous.
You'll never do it again.
It's actually quite short.
Well, I know. It is. And you went at the fair lick. So.
Court rises April.
Yes.
My lords, my lady, I shall try to match my learned friend for economy, if nothing else. May I make two preliminary observations? In my learned friend's skeleton argument at paragraph page 16 in the core bundle, paragraph 4b, he asserts...
Just a moment. 4B in the core bundle.
Yes, no, paragraph 4b, page 16 in the core bundle. It's their skeleton. They assert that, and I paraphrase, allowing the decision of Mr Justice Picken to stand would have significant implications for the law of contempt. And there's been a warming to that theme in the course of learned friends' submissions today, describing the position taken in that judgment as radical, as far-reaching an extension of the law of contempt, of being a new species of contempt, and being novel and requiring to be looked at carefully. My Lords, we respectfully doubt that it's really actually any of those things. Indeed, if there is any significant implication, it runs the other way. You'll remember how my learned friends put it in their skeleton argument at core bundle page 36, paragraph 39. They say the allegations are misconceived and bound to fail because it is simply not possible in law for the respondent to an injunction to commit a contempt, civil or criminal, in relation to that injunction without breaching it. We just pause for a moment. It's a theme that we will revisit with your leave during the course of our submissions, the structure which I'll come to in a moment. If that is right, if learned friends are right in what they say, and if any party injuncted finds an arm's length way to work around the order, with the result that the purpose of the court order may be frustrated, but not be in contempt by reason of their ingenuity, that may well be a significant implication for the law of contempt, if in those circumstances there is no remedy against the contemner. But be that as it may, we do at least agree that this appeal is demonstrably short and is amenable to a short answer. My learned friend poses his case in two different ways, a short form and a long form, in the beginning of their skeleton argument, as you have seen, to which the answer we submit is yes to the first and no to the second. We also just have this prefatory point to make concerning the proposition identified by Lord Justice Phillips as justifying consideration by this court when he frames the issue through the lens of the prohibitory injunction. His lordship said, could VietJet be in contempt of an injunction without breaching its terms? Core bundle tab 8, page 77. With the greatest possible respect to Lord Justice Phillips, we don't agree with the characterization of the issue.
Could they be in contempt of court without breaching the terms of the order?
Yes.
Is that the way you put it?
Yes. The question is not whether VietJet was in contempt of the prohibitory injunction, but whether VietJet interfered with the administration of justice by interfering with its purpose. The longer way is a less elegant way of saying what my lord just said to me. And I will take you in due course to authority to make out the point. The proper approach to the issue and showing fidelity to the authorities, many of which you've been helpfully taken to by my learned friend already, and I shall be sparing and selective in what I take you back to, but I don't promise that I won't take you back to some, allows us, I think, to deal with these matters in 5 stages. And with your leave, I will sketch out those stages now, and then I will come to expand on the first 4 before finishing with a flourish on the 5th. First, what is the purpose and definition of contempt of court insofar as orders of court are concerned? We can set to one side the many and various other species of contempt of court and hone in only on contempt involving orders of the court. Second, what was the purpose of the injunction in this case? We say it was twofold, namely, firstly, to protect FWA's entitlement to possession, custody and control of the aircraft, thereby fortifying the consent order made way back in November 2022 by Mr Justice Bryan. Secondly, prohibiting VietJet specifically from interfering with that. Third heading.
Interfering with what? Your client's entitlement.
The court's purpose in making the order to protect our entitlement.
Interfering with the court's purpose.
Thirdly, what is the conduct of VietJet under scrutiny? It goes without saying that I was not intending to, and definitely don't intend to now, treat the court to a tour of the factual background to this case. My lords and my lady have read it, and if you have the picture, I'm sure crystal clear. But it is important to bear in mind that some of my learned friends' more high-flown arguments don't sit comfortably with the actuality of this case. And it is important to bear in mind, as I know my lords, my lady will, that any judgment on this appeal must be referenced to the issues in the appeal and not to some abstract intellectual legal research exercise. So we submit 3 points can be made at this stage about the factual picture. 1, in order for criminal contempt to be proved, we have to identify the actus reus. What is the actus reus here? It is the sending in May of 2023 and then in September and October of 2023, a run of letters to the Deputy Prime Minister, Deputy Ministers and various other authorities, Customs Agency and the Civil Aviation Authority. 2, that has to be done with a purpose or an intent. We prefer the latter word, but either are used in some of the authorities, as you know, and is used in this case. What was their intention in so writing? This was a question that was posed by the judge at the hearing on the 20th of February 2025. And can I just take you, please, briefly to Supplementary Bundle, tab 23, page 323. I'm so sorry, just hang on. I think I've got a wrong reference. Forgive me. I'm told that I do have the right reference.
323,
Yes.
pages 57 to 60 of the transcript.
Yes.
Mr. Milner.
Internal transcript, page 60, line 24.
The judge.
Yes. What were they doing when they were writing these letters? What was the purpose? Answer from Mr. Milner. I don't dispute that the autumn letters were an attempt to prevent or delay.
Where have you got to now?
Over the page.
Oh yes, line 4. Thank you.
Thank you. Don't dispute that the autumn letters were an attempt to prevent or delay the export of the aircraft. So that is the context that one's dealing with. It doesn't apply to the May letters, and it is premised upon the findings of fact made by the learned judge already in trial 1. But it is important to note that we have here in combination the sending of the letters and a clear concession as to the purpose for which the letters were sent, which we say was to interfere with the purpose of the court's order in the prohibitory injunction, which is
Well, Mr. Milner goes a bit further than that, doesn't he? If we read on,
He does.
he distinguished between the export of the aircraft and the possession, custody, and control of it.
He does.
Which he characterised as a different thing.
Yes, he does. And this was an argument had partly before Mr. Justice Foxton in one of the earlier hearings in this case, in the interlocutory stages of the action, and subsequently, and it will no doubt be an issue for the purpose of the trial, of the contempt issues. But for these purposes, at this stage, noting that whether export falls within possession, custody, or control or not is an issue for later, at this stage, we respectfully submit the court should, as in all these other cases, take the facts as alleged in deciding whether or not the high bar that my own friend set at the start of his submissions is passed.
Well, if we go any further, we're going to have a deeper dive into the facts. I'm going to have to familiarise myself with what is meant by the Cape Town scheme.
Yes.
It's not something I've looked into yet.
I'm tiptoeing with uncustomary delicacy around these issues. I'm anxious not to take up my lord's, my lady's time with factual background that you don't really need. But can I come back to this in when I develop this submission?
Why have you drawn this passage Mr Milner's submissions to our attention.
For the purpose of laying before the court the fact that the VietJet's purpose in sending the letters that they sent was to achieve this.
What?
It was to prevent or delay the export of the aircraft.
Yes. Okay.
No more than that.
Thank you.
And just for your note, one could read this against two passages from Lord Oliver in Spycatcher. We'll come back to these. I don't trouble you to turn to them now unless you want to, obviously. Which on the internal numbering is page 218 at letter B or 223 at letter E. And the third factual element, which we respectfully submit is in play in this appeal, is the context in which the conduct occurred. Because whilst Learned Friend's analysis is, if I may say so, admirable for its purity, what it doesn't do is hitch effectively to what we're actually dealing with in this case and in this appeal. And I will come back to that by reference to Mr Justice Picken's judgment in due course. My fourth heading, and last effectively, is did the conduct...
So you said under 3, the context of the conduct is important.
Yes.
Can you encapsulate in a sentence or so what the context is that you're referring to?
Yes, the context is a history of serial breach and misconduct, as found by Mr Justice Picken, and I will show you what he finds rather than my gloss on them. Would you like me to show you that now?
If you're coming to it, that's fine. You're referring to the history of what the litigation was about.
Yeah, a little bit, but not so as to weary you with it or require you to become familiar any more than you are already with the Cape Town Convention, with all the excitements that holds.
Well, my lord probably is familiar with it. But serial breaches of what?
Misconduct which results in contempt 1 and 2 for a start, but I'll come back to this in a proper order.
All right. Serial breaches and misconduct. Okay.
But I think it would be helpful to set the tone if I was to show you at this stage what Mr Justice Picken found about the autumn letters, as they're rather charmingly called in Learned Friend's skeleton, and then also the May ones from Mr Justice Foxton. So can I invite you please to turn the supplementary bundle to divider 20. Do you have dividers, may I ask? The divider 20. Paragraph 200 page 220. And then to read to yourselves, please, just so you get the flavour of it, paragraphs 380 through to 388. Where he deals with the correspondence with which we're concerned here in the autumn of 2023.
problem is that while that is no doubt very bad behaviour, it's not alleged to be a breach of the injunction.
No, not at that stage. No, but that wasn't really the issue in play at all, anyway.
All right.
Now.
May I then invite you, please, to tab 11 in the supplementary bundle. In the judgment of Mr Justice Foxton from February 2024. And just to read to yourselves paragraphs 11 and 12. So when one is looking at the factual stories, which will come to under my third heading in a little more detail, and asking whether or what the conduct was and how it has been stylized, we have there two very helpful extracts from previous decisions in this case. To my Lord Justice Mayall's point, that isn't my problem, I paraphrase, forgive me, that this, we don't say this conduct itself constitutes a civil contempt. That's not a problem for us in the context of a criminal contempt allegation. And the fourth and final main heading to our submissions, did the conduct that we've just been touching on constitute a criminal contempt? Two questions. Did it frustrate the purpose of the protective injunction, as it's been called in the skeleton arguments? And if so, did it do so intentionally? And we submit that is the root of the test. Did the conduct in question, in parenthesis, whether a civil contempt or not, I'm happy, of course, to work on the basis it wasn't, because that's been the case throughout, frustrate the purpose, the words of the Law Commission, lifted from some of the earlier authorities, as you will have seen, as we may well revisit. Did it frustrate the purpose of the protective injunction? And if so, was the conduct done intentionally? What was its purpose? Double use of the word purpose, I know, which I'm trying to avoid. And then fifth and last, I'll deal with the consequences of all that and bring the threads together of our submissions. So insofar as the first heading is concerned, what is the purpose and definition of contempt of the court, insofar as orders of the court are concerned? I'd like to make, please, 7 short points, cognizant of the fact that my learned friend has already dealt, as I say, with quite a lot of this, and also I appreciate a court of this stature and experience will know very well the principles that we're dealing with. But I hope it is helpful nonetheless to briefly revisit the essential parts of that rationale of judicial learning that has been built through that run of cases in particular in the House of Lords that we've touched on some of them already, to remind ourselves of what is in play. Can we please start with Lord Diplock's speech in the Attorney General and Times newspapers case, which is Joint Authorities Bundle 1, tab 7.
It's just solidified.
Yes, it is.
As
Just
opposed to
exactly. And if we come to page 250 in the bundle referencing, and to see, what Lord Diplock here does is he describes the third broad requirement for the due administration of justice. If you'd be so kind just to get the context of what I'm talking about, just cast your eye over the paragraph beginning at B. I'd be very grateful. And then
Forgive me, which page, Mr. Lister?
Oh, sorry, 250.
Entirely my fault.
I'm very sorry.
paragraph at B. Thank you.
Thank you. If you just read at B, and then I'm going to pick it up at and thirdly, opposite the letter C. And at C, Lord Diplock says, conduct which is calculated to prejudice any of these three requirements or to undermine the public confidence that they will be observed is contempt of court. Secondly, can I please go back once more to Spycatcher, which is one tab on in the authorities bundle, and to take you once again in the speech of their lordships to, on the internal numbering page 209 in the speech of Lord Ackner, bundle page 287 at B. It has accordingly been common ground throughout this appeal that the aim and purpose of the law of contempt is to prevent interference with the due administration of justice. I invite you just to note, but I wouldn't take my lords, my ladies' time with it now, but for later reference if you find it helpful, that at the foot of page 285 at H, Lord Ackner begins a brief tour of the law of contempt beginning with the 13th century apparent roots. And it is nothing in there that I need trouble you with now, but that is what gives rise then to the accordingly common ground in this appeal is the aim and purpose of the law of contempt is to prevent interference with the due administration of justice. That's the source of it. Next, I wish to just revisit a point the learned friend has engaged the court with a little, and that is that the law of contempt has been developed so as to divide contempt of court into two broad types, as you know, albeit that the authorities are replete with material that describes this split as, using again Lord Oliver's words, unhelpful or largely meaningless. But they have an importance here. Civil amounts to, in our respectful submission, disobedience of an order made by a court inter partes, unless it's a contra mundum order, which we're not concerned with. That is the purpose of the civil order. Criminal is an open-ended category of conduct which impedes or prejudices the administration of justice. As my Lord Justice Mayles pointed out to my own friend, quite rightly if I may say so, during the submissions, that in this case, opposite to the authority he was then citing, we are dealing with a situation in which the criminal target is a broader one than the civil target. And whilst the former is hitched to the given order, the latter is more widely aimed. This was, in our respectful submission, perhaps best or most economically captured by Lord Toulson in O'Brien, which you've looked at already, but can I just remind you of paragraph 39? It's Joint Authorities Bundle, tab 14, page 470. But picking it up on 471. And it's just to remind you in this context, the first sentence of paragraph 39 of Lord Toulson's speech. A criminal contempt is conduct which goes beyond mere non-compliance with the court order or undertaking and involves a serious interference in the administration of justice. So it caters for the broader, even in his lordship's definition. And the Law Commission's paper, which the relevant part of which has been included in your bundles to reference, I don't propose to take you to it at all, because there's nothing actually directly on point on the issues raised in this appeal. But again, for your note, it is at the Joint Authorities Bundle, tab 42, page 1225. The third and consequential point that I make under this first heading is that VietJet's appeal has this issue at its core. It is premised upon these categories of civil and criminal contempts being hard silos, and in particular that where the issue relates to the substance of a court order, relates to, note, the substance of a court order, the subject of that order can only be held responsible in civil contempt for conduct violating the precise terms of the order. That one gets from their skeleton, for example, paragraph 37, or paragraph 39. We don't agree that that is a correct or fair reading of the position at all. Fourthly, the proposed restriction on the court's ability, in the words of Lord Ackner in the Spycatcher case, to prevent interference with the administration of justice is, we say, both artificial and unjustified. On the contrary to the position taken by learned friends, in my submission, the authorities are clear that the actus reus of a criminal contempt is necessarily as varied as is the nature of conduct which involves an interference with the administration of justice. In the Leveller magazine decision, Lord Diplock emphasised the open-ended nature of criminal contempt jurisdiction. And can I just remind you of that? It is in the Bundle of Authorities, tab 4, page 98. At F, my lords, although criminal contempts of court may take a variety of forms, they all share a common characteristic. They involve an interference with the due administration of justice, either in a particular case or more generally as a continuing process. It is justice itself that is flouted by contempt of court, not the individual court or judge who is attempting to administer it. Fifthly, it is further accepted in the authorities that an order or injunction has the effect of shaping or determining the way in which justice is to be achieved in the particular case. One gets that from Lord Justice Lloyd in the newspaper publishing case, the Attorney General newspaper publishing case, which is at Divider 5 in your authorities bundle. Can I just show you one paragraph from that, please? It's Divider 5, page 171. At A, maybe you'd like to pick up the reading at the bottom of the page before. Distinction between personal and other orders. And then personal orders are those that are made usually at the conclusion of proceedings, but often at an interlocutory stage, which affect the person to whom the order is directed and those who aid and abet and but nobody else. Other orders include orders by which the court regulates its own procedure and determines how a case is to be tried. And then if I could invite you to read on, please, to the end of that paragraph in accordance with its intention. Sixth of our 7 points under this first heading, and in short, the purpose of an order is to determine and define the state of affairs the court considers necessary in order to ensure that justice is achieved in a particular case. And that proposition is accepted by VietJet, at least as a matter of principle. Can I just remind you of how they put it, please, in their skeleton argument? Core bundle, page 28. Paragraph 44. where they there set out that a third party can be liable for undermining a court order in one of two ways, including by intentionally frustrating its purpose. You will remember from what we looked at already that Lord Oliver in Spycatcher, my lords, my lady, stated that frustrating the purpose of an order was interference with the administration of justice, because it frustrated the court's purpose, which in seeking to administer justice between the parties in the particular litigation of which it had become seized, the court was intending to fulfill. Now, seventh, and consequentially, the conduct by a third party in frustrating the purpose of an order is self-evidently not conduct in violation of the order. My learned friend's objection at paragraphs 48 to 49 of their skeleton, that for the purposes of contempt for frustrating the purpose of an order, the relevant conduct must involve a violation of its terms, proceeds, with all respect to learned friends, from a misunderstanding of the authorities they cite. May I make that criticism good? In fact, this is the very point that was dealt with, again by Lord Oliver, in Spycatcher. And I'd invite your lordships, please, to once again take up tab 8 of the Joint Authorities Bundle and come to page 223.
Yes.
Thank you very much. Which is page 301 in the bundle. And I wonder whether I could trouble you to read from just above C, second line of the indented paragraph, a sentence beginning "in the first place." To read that down to below E, ending with "obvious and manifest." I interrupt only to say that it is our case, and I shall show you this in terms in Mr Justice Picken's judgment, that in this case that reasoning applies, in that it was obvious and manifest, was then, is now, to VietJet, what the purpose of the courts was in making the order that it did. So the rationale here applies fully in this case. Having interrupted you, could I now invite, please, the court just to glance your eye down paragraph 223E to 224A, which we also submit is applicable in this case. It's just the top two lines of the page. The passage which I'm not going to trouble you to go back to, it's a short passage, you'll remember it very well, from the speech of Lord Nichols in Punch, paragraph 40 in his speech. For your reference, it's Authorities Bundle, page 192, behind divider 6. It is, in our respectful submission, rather misread by my learned friends.
Well, shall we look at it if you're going to
Of course, yes, of course.
invite us to reread it?
Okay. Tab 6, paragraph 40, page 192.
Yes.
To suggest, as my learned friends do, that what his lordship meant was that it follows from the fact that the purpose of an order is to be elucidated with reference to its terms, that contempt for violating its purpose necessarily involves a violation of those terms, is wrong. It's not what he's saying in our respectful submission.
Well, this is paragraph 40.
Yes,
May we read it again
of course.
in the light of that submission? So the purpose of the order is the effect its terms show it was intended
Yes.
to have,
Yes,
which you say is not necessarily confined to the terms themselves.
exactly. That's all. And in this case, it's a very good example of where there is more that informs the nature of the court's purpose, the reach of the administration of justice, and the inter partes effect of the words of the actual order made, where one has not only the order, but the application, the voluminous evidence served in support of it, and here, for this court's purposes, a judgment upon part of that.
Now, a third party wouldn't know or be expected to read any of that, would they?
A third part, no, a
They
third
would see
part.
they see the order, but they're not expected to go and read what might be a very long judgment. Still less the evidence given in the proceedings which led to that judgment.
Yes, but if a notional third party is the target here, and reads just the terms of the prohibitory injunction, which, funnily enough, in the hearing we haven't even looked at so far, I promise you we will under our next heading. They would be told straight away that there was a prohibition upon interference with the possession, custody, control, whatever the precise language is, and steps taken, whether directly or indirectly or otherwise, to impact that. So that aspect would be crystal clear. What I'm just trying to do is just to underline the generality of the point made by my learned friend, that there is more to the punch paragraph than there actually is. Should not be freighted with too much significance. I accept, of course, what my lord says. You cannot require the general public, including all third parties, to go off and be diligent beyond the terms of the face of the order. But that is not to say that in this case, that's the end of the matter, and let alone to say, and what you've got to do to be in breach is to be in breach of the terms of the order.
But you're not saying, are you, that the purpose of the order is different depending on whether you are a third party who doesn't have to go and look at all this evidence, or the respondent who might have been sitting there in court when the evidence was given?
No, I'm not saying that, no. When VietJet invites this court to find, what this VietJet invites this court to find is that the person subject to the order should be immune from the court's contempt jurisdiction with respect to conduct which intentionally seeks to frustrate the purpose of the order. And we respectfully quarrel with that analysis. It's not only because we say analytically it's not borne out by a close analysis of the authorities, but it is intuitively very odd to suggest that a party can do what we say VietJet did here and not be answerable at all in contempt.
Are you going to show us an authority in which someone in VietJet's position has been so found?
No. Unless I've missed something, and I'll obviously have lunch to look at it again. No. And one of the oddities here is that neither side can point to an authority that supports its case. We can't show you the case of A and B that says it's fine to proceed in criminal contempt against a respondent to an injunction in a private law context such as this, or any context, frankly. And they can't show you a case between C and D that says you can't. And so this may be what I think Lord Denning, rather if I may say so with the greatest respect, rather charmingly put it in Butterworth, on the cases you haven't had to look at yet, and you won't because of the abandonment of the BHP and Mariana arguments, I'm a learned friend. If the books don't have the answer, we should be writing it quite soon. Maybe there is a gap. It's only been around since the 13th century, as according to Lord Acker, as a species of remedy. But in all seriousness, no is the answer to my Lord's questions. I hope I'm not shilly-shallying about giving you.
Well, there are cases which say that the terms of the order must be clear and unequivocal
Yes.
as to what the respondent can and can't do, which Mr. Malik says implies that if it doesn't say he can't do it, then he can do it.
Well, Mr. Malik says that, yes, he does, entirely so, but it's not only a little, it's a matter of generality, not necessarily sound, but more importantly, it doesn't work in this case. And I'll show you precisely why when I come to look at Mr. Justice Picken's judgment, a little wider than just paragraph 18 that you were shown earlier.
I was wondering why Mr. Malik took us so determinedly to what Lord Justice Flood said, and the words he added, whatever the case was, pan, petroleum, was strictly construed. And I was slightly wondering what that added to it. So it's clear and unequivocal and strictly construed.
I don't think in this, can I avoid answering the question in this way? I don't think in this case that there is any gain or deficit to be had from that, considering that question, my Lord, because of this reason, that we're not talking about a prohibition of any great sophistication. It's obvious what was not allowed here. It's a matter for trial, I know, whether exports included, and taking all that as read. But for now, that argument doesn't help the learned friends. The fact is that in this particular case, what VietJet were not allowed to do, they were completely clear on. Quite clear is the understated way Mr. Justice Picken put it, but I'll show you the paragraph before where he goes into this. So they knew what they couldn't do.
Well, detecting in what you're now saying a suggestion that what they were accused of doing, i.e. impeding the export of the aircraft, was in fact covered by the terms of the injunction, which takes us back to square one.
It takes us back to whether they were in a civil breach of the order. We took view they were not, for reasons I shall come back to at 2 o'clock, if I may.
Yes.
Noting the time. I don't know whether that would be a...
Well, that clock's slightly fast, actually, but let's...
I'll gladly carry on.
Well, get to a suitable point.
Okay, well, if I may, I'll just finish this first heading, and then the others are,
Yes.
I think, shorter. I'll come to those this afternoon.
Yeah.
We're comfortably on track, even with the time that the learned friend has given me, at least in theory. Well, the judge in this case was concerned with whether or not the conduct bore the hallmarks of criminal contempt, to borrow from Lord Diplock's expression. Does VietJet's conduct exhibit the, borrowing again from his language, common characteristic of involving an interference with the due administration of justice, either in a particular case or more generally? We submit that they did breach the barrier erected by the court in defining what the administration of justice required, in this case, as expressed in the prohibitory injunction, which, as I said, I'll finish with this if I may, until after lunch, not only prohibited VietJet from engaging in particular conduct, but had been adopted to fortify the protection of a state of affairs which the court had determined should prevail until the final determination of FWA's substantive claims, namely that VietJet should not interfere with FWA's entitlement to the possession, custody and or control of the aircraft, originally ordained by Mr Justice Bryan in the consent order of November 2022. Would that be a convenient moment?
It would. We are on track, are we, Mr. Lissac?
Yes, we are,
Mr.
yes.
Mallock? We will not be able to sit beyond 4:15 today.
No,
A very strict timetable.
I quite understand. If I set myself the self-denying ordinance of not going on beyond 3:15, so I'm not seen to be grabbing time that has suddenly become available.
Yes, Mr. Mallock, are you content with that?
Oh, absolutely.
Thank you very much. Continue at 2 o'clock.
Thank you.
Rise of April